How do you contest a will? Should you challenge the will? Questions about contesting a will are very common in our office. Today, I want to walk you through some of the considerations that go into answering those difficult questions. My name is Eric Brohl. I'm the founder and CEO of Georgia Probate Law Group. At our firm, we help families who have lost a loved one navigate the complex and confusing legal process so they can make sure the estate is handled properly and their loved one's memory is honored. Let's jump into our topic for today. The decision about whether to challenge a will is a common topic in our firm, and we've handled hundreds of will contests. In this video, I want to walk you through what a will contest is, who can file one, when it must be filed, and where to file it. In the next videos, we'll discuss other important considerations such as how to object and whether you should object at all. So let's start with the question of what. What is an objection to a will? First, I need to give you a quick definition. A challenge to a will is often referred to as a caveat, which is just a legal word that literally means to challenge the validity of a will. You'll hear me use that term, and you're probably also going to see it in court documents as well. The caveat itself is a legal document, and it lays out all the objections that you have to the will. Now, we'll go over some of the most common objections in a future video. But for today, if the caveat is successful, that means the will is rendered invalid and the estate proceeds as if that will did not exist. That can have a couple of effects on the estate. One, it could mean that we fall back to a prior will. Or if there is no prior will, it could mean we fall back to state inheritance law. All of that is going to depend on the particular situation in that estate. If the caveat is unsuccessful, you don't win, then the will is determined to be valid by the court and the estate will proceed under the terms of that will. Okay, the next question to consider is who is permitted to file a caveat. Under Georgia probate law, any interested party may file a caveat. Generally, this means that anyone whose inheritance from the estate would be affected by whether the will is valid or invalid can object. But that term can also include creditors of the estate in some circumstances. When must the objection be filed? Generally, the deadline for an objection is very short, usually as little as 10 to 13 days from the time you receive the petition to probate will. Now, the documents you'll receive should include a letter from the probate court, and that letter is going to tell you the official objection deadline for your case. Since the objection window is short, don't waste any time taking action to handle the objection. Once that window passes, it can be difficult to file a caveat late, and it requires the approval of the court, which may or may not be granted. The petition to probate will may be delivered to you by certified mail, by an overnight delivery service such as FedEx, or by sheriff's service, which is just where the sheriff is sent out to physically deliver the document to you. Finally, where must the objection be filed? Well, it's filed with the clerk of the probate court where the petition to probate the will was filed. Quick note for you. If for whatever reason you believe the case should have been filed in a different state or in a different county, that's a really complicated situation and you need to get help immediately. So that's the quick what, who, when, and where of caveats. In the next videos, we're going to discuss how and whether to file a caveat in the first place. Challenging a will is a complicated process, and I do not recommend that you attempt it without the assistance of a qualified probate attorney. So for more videos and information about Georgia probate topics, click on the link in the description below and go to our website, www.georgiaprobatelawgroup.com. Now, while you're on our website, make sure to download the Georgia Probate Handbook so you know how an estate's supposed to be handled. As always, everything discussed in this video is just general information and is not legal advice. Every estate situation is different, and what may work in one estate may not work in another estate. So, to discuss the particulars of your situation, schedule a free consultation with a member of our team. As always, thank you for watching.